Virginia cannabis penalties explained clearly under current law is one of the most misunderstood legal topics in the Commonwealth. And that confusion did not happen by accident. It grew out of partial legalization, overlapping statutes, and public messaging that simplified things just enough to create risk. If you believe cannabis penalties no longer exist in Virginia, or that enforcement stopped entirely, stay with me. Because it is far more complicated than most people realize. And yeah, that tends to surprise people. Why this conversation exists. Before we talk about statutes, fines, or enforcement, I want to explain why this conversation matters at all. Virginia cannabis penalties explained clearly is not about fear. It is about legal literacy. It is about understanding where the law actually draws lines, instead of relying on headlines, social media posts, or word-of-mouth explanations. Law does not work on vibes. It works on text, interpretation, and enforcement discretion. And when those three collide, misunderstandings happen. This video exists to slow everything down and walk through what the law actually says, how it is applied, and why assumptions can create real consequences. Just know. Everything discussed here is for educational and informational purposes only. This video does not promote cannabis use, sale, cultivation, or distribution. We are discussing statutes, regulatory structure, and enforcement outcomes within Virginia law. Virginia cannabis penalties explained clearly requires us to separate personal opinion from legal reality. I will be referencing law, not lifestyle. The evolution of Virginia cannabis law. Virginia's cannabis framework did not change overnight. It shifted in stages. First came decriminalization. Then limited legalization concepts. Then medical program expansion. But those stages did not erase older statutes all at once. Instead, Virginia layered new rules on top of existing ones. And that layering is where confusion lives. Some penalties were reduced. Others were reclassified. Some remained untouched. And some were left intentionally vague, allowing enforcement discretion to fill in the gaps. This is why two people can have similar encounters and walk away with very different outcomes. Decriminalization versus legalization. Let us pause here, because this distinction is critical. Decriminalization does not mean legal. It means certain behaviors are no longer treated as criminal offenses punishable by jail. Legalization, on the other hand, creates an affirmative legal framework that allows conduct under defined rules. Virginia cannabis penalties explained clearly depends on understanding that Virginia stopped short of full legalization. As a result, penalties still exist. They are simply different in form. Let's explain the civil penalties. Most people hear civil penalty and assume it is harmless. Civil penalties can include fines, citations, administrative records, and collateral reporting. They can also escalate. A civil penalty today does not prevent criminal exposure tomorrow if behavior continues or circumstances change. And civil does not mean invisible. Records still exist. Encounters still happen. Possession thresholds and context. Possession penalties depend on more than quantity. Yes, amount matters. But context matters just as much. Location, visibility, prior interactions, and accompanying behavior all influence enforcement. Virginia cannabis penalties explained clearly must include this reality. Law enforcement officers apply statutes in real environments, not theoretical ones. Public visibility alone can transform an otherwise minor situation into a documented violation. Public use and public space. Public use remains prohibited. That includes sidewalks, parks, beaches, parking lots, and vehicles parked in public view. Even if possession itself results in a civil fine, public use can justify further inquiry. And further inquiry often opens doors people did not intend to open. This is one of the most common sources of escalation. Let's talk about vehicles and traffic enforcement. Vehicles represent one of the highest risk areas under Virginia law. Cannabis possession inside a vehicle intersects with impaired driving statutes, search authority, and officer safety protocols. Even without impairment, the presence of cannabis can complicate traffic stops. Virginia cannabis penalties explained clearly requires understanding that vehicle-related encounters often produce consequences far beyond the original issue. License suspension, court appearances, and insurance impacts can follow. Impairment and evidence standards. Virginia does not require a specific THC blood level to pursue impairment enforcement. Observable behavior, officer testimony, and field evaluations may all be used. This creates a legal environment where subjective judgment plays a role. And that subjectivity is why caution matters. Medical cannabis is not a free pass. Medical cannabis operates under a separate regulatory framework. Patients must comply with registration, possession limits, authorized products, and usage rules. Failure to meet any of those requirements can remove statutory protections. Virginia cannabis penalties explained clearly includes this uncomfortable truth. Authorization is conditional, not absolute. Distribution and transfer risks. Sharing cannabis, even without money, may still qualify as unlawful distribution. Intent, quantity, and circumstance matter. Virginia law does not broadly permit transfer outside of very narrow allowances. And it is here where penalties escalate fastest. Distribution-related violations can move from civil to criminal quickly. Local ordinances and enforcement discretion. Virginia localities retain authority to enforce zoning, nuisance, and administrative codes. Norfolk and other Hampton Roads jurisdictions may apply local rules that interact with state law. This creates a patchwork effect. Virginia cannabis penalties explained clearly cannot ignore local governance. What is tolerated in one city may be cited in another. Collateral consequences explained. This is where the law becomes invisible but powerful. Civil penalties can affect employment background checks, housing applications, professional licensing, and probation conditions. They can also intersect with federal systems. And these consequences rarely show up in headlines. But they show up in real lives. Who this actually affects. This affects students, workers, renters, medical patients, visitors, and long-term residents. It affects people who rely on partial information. It affects people who assume silence equals permission. And it disproportionately affects communities where enforcement scrutiny is higher. Why legal clarity matters. Virginia cannabis penalties explained clearly is not about punishment. It is about informed decision-making. Legal clarity allows people to avoid unnecessary exposure. Confusion creates risk. Knowledge reduces it. Here's a scenario walkthrough. Let us walk through a realistic scenario. A Norfolk resident possesses a small amount of cannabis in a parked vehicle outside a public venue. The substance is visible. No impairment is observed. One officer issues a civil citation. Another might investigate further. Same facts. Different outcomes. Context, discretion, and interpretation matter. What to watch next? In upcoming videos, we will examine how cannabis penalties intersect with housing law, employment screening, probation terms, and local zoning enforcement. Always legally framed. Always documented. So, here's my question for you. What assumption about Virginia cannabis penalties explained clearly turned out to be incorrect based on current law? Put your answer in the comments. Please like, comment, and subscribe for more videos like this focused on Virginia law, regulation, and compliance.